This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I think it's worthwhile to speak about the construction contract, which is important to every insurance lawyer, claims representative, or anyone involved in a construction defect case. When a construction contract, like every other contract, is unambiguous, the party's intent may be determined from the contract alone, and it is the duty of the court, not the jury, to state its meaning. Construction contracts are governed by the same rules as all other contracts. When a court is called upon to interpret a construction contract, its terms are given their ordinary and generally accepted meaning, with the court working to give effect to the intent of the parties to the contract, unless the contract itself gives special meaning to the contract. If the aims are kept in mind during drafting, a construction contract should be reasonably straightforward to understand. A contract benefits both the contractor and the owner. Both parties need the contract as protection from each other. A construction contract should always be written. It should, like all other contracts, set forth in detail the duties and obligations of the parties to the contract. It should communicate the scope of work to be rendered and the extent to which each party is involved in the differing aspects of the project. Contracts serve as means of documenting the services and assets to be exchanged during the course of a project. The contract is important not only to finalize the deal in the minds of the parties to the construction project, but also to help define the performance of the work and may even determine who bears the tax burden or the burden of tort claims that may result from the basic construction project. A construction contract is often considered to be a brilliant means of transferring risk from one party to another, much as insurance is a risk transfer device. A basic construction contract is negotiated by the parties and will be interpreted following the normal rules of contract interpretation. When the parties to the contract are of unequal bargaining power, such as a multinational corporation dealing with a local builder, the more powerful party can force the less powerful party into a contract not subject to negotiation, the infamous contract of adhesion. The less powerful contractor is only able to specify the amount of compensation. The negotiated contract, where both parties deal equally with each other, is preferable and fair to both parties. When dealing with large or powerful entities, there is no way to avoid the contract of adhesion. However, even a contract of adhesion is subject to negotiation over price and some terms and conditions. Negotiation should never be avoided. Very few contracts are take-it-or-leave-it propositions. Adhesion contracts can be left intact, but modified by endorsements signed by all parties. All contracts should be negotiated at arm's length, recognizing that no two contracts will be exactly alike because no two properties are exactly alike. As the U.S. Supreme Court explained, quote, such value may be good evidence of the maximum available if one can assume the parties of equal knowledge and negotiating skill agreed upon the figure through arm's-length bargaining, unhindered by any considerations tugging against the interest of the parties ostensibly represented in the negotiation. This was Ortiz versus Fiber Board, a 1999 decision of the U.S. Supreme Court. Although an arm's-length contract negotiation usually requires both parties to be equal, some may be more equal than others. The contracting parties should, within reason, use the power available to their benefit. If one party is weaker than the other, and the terms proposed will make it difficult to profit from the transaction, the weaker party always has the option to refuse to enter into the contract. When a contract of adhesion is accepted, the courts protect the weaker party and, because of the unequal bargaining power of the parties, treat the contract of adhesion differently than a negotiated contract. Courts will interpret any ambiguity in the contract of adhesion against the drafter of the contract to equalize the rights of the parties and prevent the stronger contracting party from taking advantage of the weaker party, just as they do with insurance contracts of adhesion. Contracts of adhesion should be avoided if at all possible. Although the profits that can be made from a contract of adhesion often outweigh the one-sided nature of the contract, the builder or contractor who signs a contract of adhesion should read the contract carefully and preferably have it reviewed by his or her counsel to ascertain that all of the conditions can be and will be accomplished before the contract is signed in a manner that will result in a profit. Clearly, purchasing a standardized and industry-accepted form is less expensive than asking an attorney to draft a specific contract from scratch. Although on a large project, it is often a good idea to involve counsel to review and/or modify the standardized forms to protect the client's interests. Generally, though, sources that create construction contracts are equipped to protect standardized form users because they are familiar with new case law that affects the interpretation of contracts, new statutes that affect the interpretation or application of contract terms, the need to resolve legal issues that become apparent so that they will not arise in future contracts, the need to conform to changing building codes and construction-related statutes, and the need to conform to changing insurance policy wording and regulations. The most extensively used standardized forms are those that have been developed by the American Institute of Architects. AIA contract documents have defined the contractual relationship in the design and construction industry for 120 years. AIA contracts can save the parties time and money, are up to date and constantly revised to provide assistance in dealing with new design and construction issues. The contracts can even be purchased now in MS Word format so that they can be adapted to particular contract needs. AIA document and contract forms are intended for nationwide use. They are not drafted to conform to the law of any one state. People using the standardized contracts must be cautious and seek counsel from a knowledgeable attorney to be certain that local jurisdictional or substantive law does not contradict or make unenforceable the standard language of the contracts. With that warning, however, AIA contract documents and other form contracts can provide a solid basis of contract provisions that are enforceable under the law existing at the time of publication in most jurisdictions. AIA is not the sole source of standardized contract documents. Other publishers have created standardized contract forms, including the Canadian Construction Documents Committee, the Design Build Institute of America, the American Subcontractors Association, and many other sources available on the Internet. Forms can also be purchased at building supply stores or may be drafted by local counsel or by independent contractors or subcontractors. For example, some contractors use a one-page form with the terms and conditions attached as an appendix. Others attempt to draft complex contract documents by cutting and pasting parts of contracts presented to them by other builders, architects, and developers. This practice is hazardous to the contractor's or developer's bottom line. To be understandable, a contract must be internally consistent. When bits and pieces are taken from various sources and put together, the document can become incomprehensible and invariably create future litigation. If the contractor or developer refuses to use a standardized form, it would be best to obtain the services of an attorney familiar with the construction industry to draft a contract that, 1, is specific to the needs of the client, 2, is internally consistent, 3, contains conditions that are favorable to the client, 4, contains protection for payment of the contract price, and 5, contains an effective arbitration clause to avoid litigation. Since construction contracts are unique, it is often in the best interest of the parties to enter into an arm's-length construction contract to retain local counsel to create a contract to their specifications after the major issues are resolved by negotiation. The contract would, in the precise contractual language that attorneys use, set out the positions of both parties, explain the duties and obligations of both, and make it difficult, if not impossible, to fail to fulfill those requirements. The cost of hiring an attorney before the contract is completed can save the parties hundreds of thousands of dollars in attorney's fees if there is a contract dispute, not to mention damages. An owner presented with a non-standard contract should never accept it as presented. All contracts, except contracts of adhesion, are subject to negotiation. It is imperative that both contracting parties review the contracts carefully, and best practice to do so with advice of a competent and experienced construction-related attorney. Almost all construction professionals are familiar with AIA and other standardized documents and can quickly evaluate the proposed transaction based on the modifications made to the standardized documents. If those modifications stand out, if the document has been retyped or scanned and the modifications are blended into the text so that the changes are not readily apparent, the person modifying the document can be charged with attempting to deceive the other parties to the contract. The modifications themselves may be derived from another type of document published by the AIA. These are all model documents. The model documents use standardized language to modify contracts to meet the particular needs of the contracting party. The language is intended to be reproduced and adapted by users to give a customized feel to standard documents. Standardized documents are designed to be used as written with the parties merely filling in blanks for the names of the parties, the location of the project, and the project price. Model contracts, on the other hand, are designed as a foundation for a contract that is subject to customization to meet the needs of the parties. The parties can effect a cost savings by instructing counsel to use the model forms as the bases of customized contract creation. This video was adapted from my book Construction Defects and Insurance, Volume 1, which is part of an 8-part treatise on construction defects and insurance, available as both a Kindle book and a paperback from Amazon.com. And it has a great deal of further detail about construction contracts. If you found this video to be useful or interesting, please forward it to your colleagues. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can be advised of future videos and future blog postings. Thank you for your attention.